gives us a chance to talk about a little bit what we've seen so far today. Joe McCullough is with us, along with John Mobley, both in Columbia, South Carolina. Good morning to both of you again. Good morning to you again, Joe. And John, good morning to you. John, this case, right now the state is painstakingly giving jurors the sense of the neighborhood, their goal to give people a sense that this man, that is the defendant, Stanley Ford, he became unhinged. He was the protector of the neighborhood, and then boom, it just got to be too much for him, and he set these devastating fires. Your take on the state's case so far? It is a death case.
Well, I think, from a defense standpoint, this is a perfect case for what I like to call legal judo, which is basically using the strength of the state's case against them. They're saying their motive is he's this unruly neighbor that has odd behavior, and what the defense needs to do is say, hey, the bottom line is a murder got committed, that there was an arson, there was no real suspect, but the neighbors didn't like this guy. They thought he was odd, so he became the real suspect. And hey, we've got a video of an unidentified black man committing a crime, so it's got to be him. So, and the fact that they're spending so much time talking about his odd behavior kind of reinforces that. And I believe that the defense will and should argue that this resulted in a real rush to judgment, because instead of having law enforcement conduct an unbiased investigation, they're letting the neighbors really drive the investigation by identifying, Mr. Ford as a primary suspect. So what happens is, in a situation like that, is law enforcement, instead of conducting a thorough investigation, they make their mind up and rush to judgment that this guy is the suspect, this is their guy. And what they do is they try to look for and find evidence that affirms that belief. While doing so, what they do is they ignore evidence that indicates he did not commit the offense, and more importantly, evidence that indicates that someone else committed the offense. So that's kind of what I'm seeing right now. That the defense should keep it relatively simple, because the bottom line is ask the same question over and over to the jury. What evidence do they have that this man committed the offense? Forget about the fact that he's odd. Forget about the fact that neighbors don't like him. You argue with this neighbor. He's not on trial for being odd. He's not on trial for being strange or being a difficult neighbor. He is on trial for intentionally setting fires. What evidence do they have that this man committed that offense? And if you ask that question over and over, it really kind of breaks down for the state, because they keep going back to, well, this neighbor didn't like him. He argued with this neighbor. He was odd here. He was in conflict here. Well, that's wonderful, but he's not on trial for that. What's the evidence that he committed the arson? And that's where they're going to fall short every single time.
Yeah, it doesn't appear as though